number 1, STRB 41 of 2002.
The questions have been answered in favor of the SSC and against the department.
Item number 2, WPC 6554 of 2004.
The writ petition is allowed. The impugn order under Annex 3 is hereby quashed.
Item number 3, JCRLA 51 of 2007.
We've affirmed the conviction, but we found that in the meanwhile, his sentence has been remitted and has already been released. So nothing more needs to be done.
Item number 4, WPC 10986 of 2008.
Writ petition is dismissed.
Item number 5, WPC 6120 of 2009.
The writ petition stands dismissed.
Item number 6, WPC 25280 of 2019.
The writ petition is dismissed.
Lordship, pardon me, at the cost of disturbing the lordships and on the eve of the holidays, an urgent matter relating to this 148 notice minutes. 1314 assessment. If your lordship would pardon me, my lords, for disturbing your lordships.
No, no, sir.
And your lordships roast terminals.
So this is covered by that matter.
My lords, Nutan. And my only prayer, my lord, is annexures 2 and 3 are the consequential assessment orders and demand notices that may be quashed. Your lordship have also observed it.
10.
I've agreed with Mr. Dalla.
Sorry.
So the petition is allowed, no orders is to pass. Grateful.
Supplementary fresh admission, item number 2.
My lords, item number 2, I appear for the petitioner, my lords.
Yes.
This is an application for appointment of a substitute arbitrator, my lords.
Right.
The arbitrator who was earlier conducting the proceedings has had to recuse. After his recusal, my lords, I had made a request to the other side that your lordships will find at annexure 12, page 134 of my petition, my lords. The bottom of the page, my lords, substitute the last two paragraphs. Aforesaid unfortunate and illegal conduct and consequent recusal, mandate of the present arbitrator stands terminated in terms of section so and so of the Arbitration and Conciliation Act. A substitute arbitrator is now required to be appointed as legally required / mandated under section 15, subsection 2 of the Arbitration and Conciliation Act. Mr. M.R. Mohanty was appointed.
To go in this now.
Sorry, my lords.
Notice will have to go in this, or notice returnable. 22nd July. Right.
Item number 3, ARVP 12 of 2022.
What is the actual one?
Lords.
Milords.
There's no arbitrator. But what is this matter? No, this ARV 32 is what? All right.
ARVP 12 of 2022.
Milords, I have filed this, the counter was awaited, but Union of India has not filed its counter as of yet. In the meanwhile, what they have done after receipt of notice from this.
Yes, they have got the copy of the same. Lordship, allow 4 weeks time. In the meanwhile, we will file the counter. We have received the copy.
Lordship, in the meanwhile, the arbitrators are proceeding. It is against Dr. Switchgear judgment, which says that once I'm before this honorable.
So let the arbitration not proceed, Mr. Pari. Then you say Mr. Pari seeks some more time for filing counter affidavit. Last opportunity is granted to file counter affidavit within 4 weeks, joined up for the next date. No further proceedings shall take place in the before the arbitrator who is already conducting proceedings.
Much obliged, much obliged.
In the next day or till further order. List on 22nd July.
Obliged, ma'am.
Specialist. Specialist for orders, item number 1.
Not pressed. Disposed of is not pressed. All right.
I be pardoned, my lord, I could not remain while the judgment was.
No, I have accepted your arguments, so it's been allowed.
My lord.
All right.
My lord.
Let us see what happens.
My lord, obliged.
All right.
Item number 2.
Doctor not pressed. Okay. All right. The memo is taken on record.
Specialist, item number 3.
Item number 3, Lordship, opposite party is the wife of the petition number 2, Lordship. They has filed the 1/6 case in ADGM Bhubaneswar, and cognizance has been taken. That has been checked. But
So you can reserve all these pleas. You say reserving all the pleas to be taken at the stage, appropriate stage of the trial court. The petition is disposed of. Interim order is vacated. A copy of this order be communicated to the court counsel.
Specialist, item number 4.
None appears dismissal of assertion.
4.
You're in 4. All right.
May I please, Lordship? Lordship, this is the matrimonial dispute, and I am the husband, Lordship. And opposite party number 2 is the wife. And Lordship,
Requisites have not been filed for all these years. For 8 years, no requisites filed.
but Lordship, in my record, that is filed on 24/6/2014.
You have to follow up on these things. The registry says requisites not filed. Anyway, all the pleas are reserved to be urged before the trial court. Same order. Same order. All right.
Obliged.
Specialist item 5.
None appears dismissed and no prosecution. Interim order is vacated. Right.
Specialist item number 6.
None appears dismissed and non prosecution. The interim order is vacated.
Specialist item number 7.
None appears dismissed and non prosecution. Interim order is vacated.
Specialist item number 8.
Same order. Dismissed and non prosecution. Interim order is vacated.
Specialist item 9.
None appears dismissed and non prosecution. Interim order is vacated.
Item number 10.
Same order.
May I please, Your Lordship?
Yes.
As both the parties are living happily and continuing their conjugal lives happily, I may be permitted to withdraw the case.
All right. Counsel, the petitioner states that he seeks to withdraw the petition since both parties are now happily residing together. Dismisses withdraw. All right.
Obliged.
Item number 11.
None appears dismissed and no prosecution. Interim order is vacated.
Specialist item 12.
May I please, Your Lordship? Lordship, challenges here with the FIR dated 18/2/2011 for commission of offences under section 379 or 1134 IPC and section 21 of MMDR Act. Lordship, here the allegation was that the present petitioners were the receivers of diamonds, gemstone, are Sinapali. This is the only allegation. And section 21 will not be attracted in this case because section 22 of the MMD Act says that no court shall take cognizance of offences punishable under this act or any rules made thereunder except upon.
It's still being investigated. Final form has not been submitted. At that stage, you got stay.
Lordship,
let the investigation be completed, sir. 10 years gone. You got the investigation stayed for 10 years. You say the permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated. The order be sent to the concerned court for truth. Yes.
Item number 13.
None appears dismissed and non prosecution. The interim order is vacated.
Specialist item 14.
Doctor, not pressed. The memo is taken under record. All right.
Specialist item number 15.
None appears dismissed and non prosecution. The interim order is vacated.
Specialist item number 16.
None appears dismissed and non prosecution. The interim order is vacated. Right.
Item 17.
Same one.
Specialist item 18.
May I please, Your Lordship?
Yes.
Your Lordship, liberty may kindly be granted to agitate all the points at the time of final adjudication.
All right. Seeks to withdraw the liberty to press all the points urged in the present petition at the time of at the appropriate stage of the trial court.
Obliged.
Interim order is vacated. Copy the order be sent. All right. All right.
Specialist item 19.
Here is a case where we are the officers of Utkal Aluminium International Limited. There is some allegation by the villagers with regard to construction work against the Simplex, another company. And they have named our name, given our names. Therefore, I have filed this case for passing the proceedings so far we are concerned.
Same thing, so you can urge all this.
But the whole difficulty is, your lordships are right, I don't stand on the way, but the whole difficulty is the allegation is under section 3 SC/ST Act. So difficult will be there for getting the bail and other things.
That can't be helped. That can't be helped. You see, because 10 years have gone by. Maybe this court will be more lenient than.
No,
permitting the petitioners to
make
urge
some
all the pleas taken in the present petition at the appropriate stage before the trial court. The petition is disposed of. The interim order is vacated.
I may be pardoned, my lord. Item number 16 and 7 in the board is showing, my lord, 12, my lord.
I know. We are going fast. That's why. Tell us. What is it?
Your Lordship, give some observation relating to that.
No, it will be open to the petitioners to seek appropriate reliefs before the trial court. Right. 16.
My lord. Item number 16, my lord, I have challenged the order rejecting my application for discharge, my lord.
Okay.
I have been charged under section 212 of the IPC, my lord. The allegation is that I have deposited some amount in the account of the principal accused, my lord, after he has committed the offence, my lord.
All right.
That is the only allegation against me.
But you can take all these pleas at the appropriate
My
stage.
lord, in this case, my lord, only one thing I will submit before your lordship. In this case, the trial of the principal accused is going on, my lord. And it is already far end of the trial, my lord, the IO is to be examined.
Right.
Therefore, my lord, your lordship may kindly grant me time so that after conclusion of the trial, then, my lord, I can move this application, my lord. Because so far I am concerned, I have not been faced any trial, my lord.
I know.
Because of the stay order passed by this honorable court, my lord.
No, but anyway, vis-a-vis you, the process will have to start, correct?
My lord.
So that will take time anyway. That will anyway take time.
My lord, if, my lord, the principal accused will be acquitted from the charges,
Then all the more better for you.
then, my lord, I pray, my lord, this matter may be kept pending, my lord. It is, my lord, already it may be taken up in the reopening.
We
day,
don't
my
know
lord.
all that. We don't know. It's
taken
already 10 years old. More than
And one thing your lordship will kindly see, the allegation, the petitioner is a advocate's clerk, my lord.
All right.
He has gone to the bank. Somebody has requested to deposit the amount in an account. He does not know whether that account is
Madam, advocates, clerk in district courts are much more informed than advocates. You know that. They are doing all the work. Those advocates, clerks in district courts are much more than advocates. Everything is being done by them. So they are not unaware.
I don't know whether that amount to disappearing the evidence.
So anyway, that plea you take, you say reserving the right of the petitioner to urge all the pleas raised in the present petition at the appropriate stage before the trial court. The petition is disposed of. The interim order is vacated.
My lord, next item, my lord.
70. Yes.
Here, my lord, matrimonial dispute.
1 minute. Some connection is gone.
Item 22, no instructions for now.
Lordship may kindly come to page 22, Annexure 3. Now, Lordships, in page 22, there is Annexure 3. The opposite party is only additional PP. Now, Lordships, I am being directly covered by a judgment of the Honorable Supreme Court. It's a 3-bench judgment. Only 2 lines, Your Lordships. With the permission, I would like to read. That's it. How can the magistrate correct the error at the time of framing of charge? They can't do it, Your Lordships. But in revision, when the revision was allowed, Your Lordships, the person against whom an order has been passed, he should have been given a hearing. Oh, this was without notice, Your Lordships. And it is directly being covered by this Justice Lodha's judgment, Your Lordships. Who's for the other side? Yes, who's for the other side? Other side, Your Lordship, nobody's happy. That's it.
They have also filed a counter affidavit that we have flagged 10.
But the law is clear, we should have been given a hearing. PK Pani. Yes. He is not there today. After implementing the present petitioner as opposite party number 2 and proceeding thereafter in the matter, the said revision petition will be listed before the Sessions Judge Khurda, Bhubaneswar on 18 July 2022, on which date the present petitioner shall remain present before the court. The petition is disposed of. Obliged, Your Lordship. Yeah.
Special list item number 24.
Right. Please, Your Lordship. Right, please, Your Lordship. I am appearing on behalf of Mr. Mohanty. No choice.
24. Item 24 for me. It's my case.
Item 24, CLMC 2758 of 22.
What item is, what is your petition number? Tell us your petition number.
It's my. This is matter of Chinno Chaudhary, not Chinno.
All right. Yes. Yes, please.
Passing on the, I just want to place one document for consideration of your Lordship. I filed it in the memo on 10th. Your Lordship can see at page 4. My memo dated. Eight 10/2012.
All right, tell us what the matter is about. Tell us.
Petitioner is this is the document. I only because I only submit before your Lordship. The innocent person should not be face the trial because of the false FIR manner. In same allegation, pursuant to the direction of the SST department, a inquiry has been conducted by the collector. This is the report. I have. You also may kindly see at page 4. A joint report was conducted by the block development officer, district welfare officer, and allegation is illegal transportation of rice from school to another place to remand Ashram School on 7/7/2012 at 12:30 p.m. in presence of the school teachers, watch and ward, and the hostelers of the school. During inquiry, the following facts were found out.
No. This FIR is still at the investigation stage, or charge sheet has been filed? Charge sheet has been filed or investigating?
That I have to take instruction.
No. 1 minute.
You Lordship may kindly see. This is the.
No. It's still a GR case. I don't think any charge sheet has been filed yet.
No, my instruction that was obtained in the 2014, the investigation of the case has already been completed since April 2014.
2014?
Yes.
So you can point this out to the trial court. Apply for discharge, sir.
Your Lordship may kindly prove. Just 2 lines I want to prove, your Lordship.
No. This is a joint inquiry report.
Yes, ma'am.
This is not a material that the judge has looked at. The trial judge has not looked at this material, sir. You place it before him. Let him apply his mind to this. You say, counsel the petitioner, I'll refer to this.
Yes, ma'am.
Refers to a joint inquiry report dated 7 July 2012, conducted by the District Welfare Officer Jasuguda, BDO Lakhanpur, and
last 2 lines, your Lordship.
What is that extension officer? Welfare extension officer,
Yes.
Lakhanpur, which states that there may not be any theft or malafide intentional part of the school teacher. Paragraph. It now appears that the investigation is already complete. In the circumstances permitting the petitioner to place the joint inquiry report along with an appropriate application for the trial court, the interim order passed by this court is vacated. All other pleas urged in the present petition are also permitted to be urged before the court concerned. The petition is disposed of. The copy of the order be sent forthwith to the
Specialist item number 25.
None appears. Vacated. Stays vacated. Yeah. Copy of the order be sent.
Item 26.
None appears. Desist non-prosecution. Interim order vacated. Copy to be sent to the concerned court.
Item number 27.
27, my lord, it's a challenge to cognizance order. I did.
So you can urge all the pleas, sir.
At the time of charge.
Right. You say all permitting the petitioner to raise all the pleas urged in the present petition before the trial court at the appropriate stage. The interim order is vacated. The
At the
petition
time of framing charges.
appropriate stage is more than enough, sir, for you. Right.
Specialist item 28.
Pardon, my lord, no instruction permitted to
All right.
withdraw.
Permitted to withdraw, dismiss as withdraw. All right.
Specialist item 29.
Madam, in the present case, the offense under section 366 and 363 of IPC, the opposite by 2 number is the victim, who was major at the time of occurrence, and both the petitioner and the opposite have married each other, and out of their love affair, the marriage was solemnized by exchange of guidelines as per Hindu rites and customs. I am mentioned in para 4 of my petition. And after their marriage, they both.
Is there an affidavit by the other side?
Yes, my lord. At affidavit file B, my
All
lord.
right. Opposite party number 2 has filed an affidavit in this court admitting that she and petitioner have married, are living together, husband and wife, and she does not want any further proceedings against the petitioner. That view of the matter, the FIR in question is lodged, is quashed, hereby quashed. The petition is allowed, no orders to pass.
Specialist item number 30.
Case in which prayer was for passing of the criminal proceeding, and this is a case under section 138 of NI Act. My lord, my grounds of submissions are that issuance of notice is time barred beyond one period of 1 month, as well as filing of the case is time barred, and it has not been filed within the prescribed time. And your lordship may kindly
Has the other side been served, sir?
Other side notices were issued in 2014.
No, were they served? Let us see. Not filed, requisites not filed, sir. Filed in time, all right. Served.
My lord, the page 8 of
All right, all right. Yes, it's time barred, is it?
Yes, ma'am.
What is your plea, Mr. Modli?
So it's a complaint case.
All right.
Statutory notice was to be issued within 1 month, and case was also to be filed within a period of 1 month from the date of cause of action. Both the things were violated, and cognizance has been taken, my lord. The complaint petition itself is self-explanatory. Page 8, my lord. Page 8 of the complaint petition is sufficient to conceive that these violations are there.
What is that? Just say.
My lord, may I read your lordship?
Yes, please.
Page 8, my lord.
Yes.
My lord, first para that as the accused could not and did not supply the aforesaid.
So 2nd August 2010 was the dishonor.
Yes, my lord. Two checks. The first mistake the complainant committed by filing one case comprising of two checks, and both the checks were, my lord, of dated 28/7/10 and 30/7/10. My lord, it was both the checks were dishonored on 2/8/2010.
All right.
So notice should have been issued by 1/9/2010, and it was not.
All right. All right. You see, the short point urged in the present petition is that the complaint was filed under section 138 of the Negotiable Instruments Act 1888, (NI Act), beyond a period of 1 month from the date of dishonor of the checks in question. The checks were dishonored. The checks which were dated 28th and 30th July 2010 respectively, issued by the present petitioner, were dishonored upon presentation, on 2nd August 2010. As the complaint itself shows, the statutory notice was issued by the complainant only on 29th January 2011, that is much beyond the period of 1 month from the date of dishonor of the checks. Paragraph. On that short ground, the complaint could not have been allowed to proceed, and the order passed by the learned SDJM Khurda, taking cognizance of the offence under section 138 NI Act in 1 CC number 99 of 2011 is unsustainable in law. The said order of the SDJM is accordingly hereby quashed. The petition is disposed of. A copy of this order be sent to the concerned court forthwith. Right in the beginning, you said, despite service of notice, none appears on behalf of opposite party number 2 complainant.
Specialist item 31.
My lord, here what has happened, there is a case and cross case. Parties are similar in both the cases, and both parties at the pre-cognizance stage, my lord, wanted to withdraw the case, withdraw their respective cases.
But these are compoundable, non-compoundable?
My lord,
if it is grievous hurt, then non-compoundable, sir.
No, my lord, your lordship, at the pre-cognizance stage, my lord, such petitions were filed by the parties.
No, what is the offence?
Offence, my lord, your lordship, offence is 341, 323, 294, 506 by 34 5. My lord, among the only 294 was non-compoundable. And cognizance was taken on 17/12/2012, whereas petition for withdrawal was filed by 30th August 2000.
No, first of all, have you made the other side a party? You have not. So that itself is a problem, sir.
No, issue notice was, my lord, on last date, on 18th of March 2000.
You have made them. 2 to 5 are the opposite parties. Have they been served?
Notices were issued.
No. Have they been served? They appeared. Are there affidavits and records, sir? So the affidavits have to be recorded in the court below. You get the statements recorded in the court below. That's and apply for discharge.
My lord, appropriate direction may be given.
All right. You say, according to the petitioner, the petitioners and the opposite party 2 to 5 have already settled all their disputes. Full stop. However, none is appearing on behalf of opposite parties 2 to 5. And their statements, the sworn statements, are also not on record. Consequently, permitting the petitioners as well as opposite parties 2 to 5 to have their respective statements recorded in the trial court, and on that basis to apply for discharge, the petition is disposed of.
Specialist item 32.
Order is vacated. The copy of the order be sent to the trial court forthwith. No instructions. 32 dismissed. Interim order is vacated.
Specialist item 33.
Yes. Neither AD nor unserved notice received back from opposite party number 2.
Here, the petitioner and the opposite parties, they are related persons.
That's right.
The suit was filed for partition by the opposite parties in the principal civil judge under Annex 2 and 2A. Thereafter, my lords, they filed a complaint application before the JMFC Basudepur and the JMFC Dasdepur, he under section 156(3) sent it to the police for
Investigation.
And
Right.
the police, Lordship will kindly see Annexure 6, page 43.
Yes.
The police said that the affair is false. And just the case is case record case is written as FIR is false under
So protest petition must have been filed.
protest petition filed. And
notice.
on the protest petition, the learned trial court
Has issued notice.
he took cognizance and at
So you can urge all the police, Mr. Rai. You can urge all the police. The other side is not here.
other side is not here.
So you urge all the police. You've got a 10-year stay now.
That 10-year stay, man.
Sting has been taken off. Sting has been taken off. So by the time you go back, there will be no complainant.
As your lordship, please.
All right. Permitting the petition to urge all the police
What I
raised
say,
in the
my
present
lord,
petition.
there is an interim order by this honorable court.
I'll vacate it, but nothing immediately will happen there. You go there and raise all these pleas. You say permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. There will be no complainant. That's what is going to happen. All right.
Rightly pointed.
All right.
Obligement.
All right.
Item 34.
May your
None of-
lordship allowed to withdraw the matter to
Yeah,
FISA?
counsel, the petitioner seeks leave to withdraw the petition with liberty to press all the points urged in the present petition at the appropriate stage of the trial court.
Obliged.
Dismiss is withdrawn with liberty is paid for. The interim order is vacated. All right.
Specialist item 35.
35 my directly covered by Supreme Court decision, my lord. 498A, marriage was declared null and void, my lord. Thereafter, she filed a 125 petition that was also dismissed, my lord, because she didn't appear. Now, after that, she filed a complaint petition. Entangling the entire family. We are staying alone at West Bengal.
Sir, what has she been issued notice here? Was she given notice in this petition?
Yes, my lord.
She may not turn up there also, sir. Permitting the petitioner to urge all the pleas raised in the present petition the appropriate stage of the trial court. The petition is disposed of. The interim order is vacated. A copy of the order be
But
sent
she
to the
has entered by this court has taken cognizance of the complaint
whatever, sir.
petition.
Without hearing her, we can't pass any order. So let it go back. She won't appear there now. If she's staying in West Bengal, where will she come?
No, I am staying West Bengal. She is filed at Puri.
It's a 10-year stay. Nothing will, the Lord forgotten. They would all carried on with their lives. She won't even appear in that court. Yes.
That's it. Kind of that Supreme Court decision. I will take that.
You take all that, please, sir. Right.
Specialist item 36.
All right.
Specialist item 37.
None appears dismissed and non-prosecution. The interim order is vacated. Copy of the order be sent to the concerned court.
Specialist item 38.
None appears dismissed and non-prosecution. Copy of the order be sent. Interim order is vacated. Copy of the order be sent.
Specialist item 39.
May I please, Your Honor? My lord, please, page number 6, para C, that the petitioner is just merely a worker and the company has not been made a party.
I see.
And
All right.
my lord's order.
Yes, yes. Only last week.
Yes, my lord, order
All right.
in respect to Anita Hada.
All right. A sales executive.
My lord.
Oh, wife of the director. Okay, the
My lord,
petitioner is the wife of the
is-
director of a company which has not been made an accused.
Yes.
In the complaint case, ICC case number 266 of 2012.
Yes, my lord.
Filed by opposite party number 2.
Here the company.
In the court of the SDJ in Bhubaneswar.
Yes, my lord.
Under section 138 of the NI Act, Negotiations Act 1888. As explained with the Supreme Court of India in Anita Hada versus Godfather Travels and Tours Private Limited, 2012 5 SCC 661, without making the company a party, a director thereof cannot alone be made a party to such a complaint. On that short ground, vis-a-vis the present petitioner. ICC case number 2266 of 2012 stand quashed. It is made clear that it will, however, proceed against other accused in the matter, in the complaint. The petition is disposed of.
Minus.
3040 is also the same.
The same thing.
Same order in 40.
The order may kindly be quashed.
Specialist
41.
41.
None appears, dismissed and non-prosecution, interim order vacated. Copy the order be sent.
Specialist item 42.
Yes.
Merit, this is a negotiable instruments act of merit.
Correct.
The petition for compromise was filed, and he has accepted 2 lakhs rupees out of the
That affidavit has to be filed, sir.
Pardon me, Lord?
An affidavit has to be filed with the complainant. Without that, we can't simply record it.
That he has not done it, Merit. That's why I'm praying, Merit, they reconsider the petition for
No, but
compromise.
has been served here.
Yes, he has heard, but he has denied. He backed out.
So that's why you'll have to urge it before the court then. You'll have to record evidence. Permission petitioner to urge all the pleas raised in the present petition before the concerned trial court at the appropriate stage. The petition is disposed of. The interim order is vacated.
Before proceeding ahead, Merit.
Or copy of the order be sent to the concerned trial court.
Specialist item 43.
Infractuous. Counsel to petitioner states petition is maintained infractuous, disposed of as such.
Specialist item 44.
May I please, your lordship? My lord, here the petitioner challenges the order dated 18/5/2013, my lord, rejecting the petition under section 205 of CRPC, my lord. My lord. Petitioner number 1 and
What's
2.
the offense?
Offense, my lord, 498.
Why should you apply for 205? You could have easily appeared. You are the father or father-in-law?
Father-in-law, mother-in-law, and brother-in-law, my lord. Brother-in-law is staying at Bangalore, and father-in-law and mother-in-law are old and ailing, my lord. They are sick.
How old are they?
Now they, at the time of filing of the petition, my lord, petitioner number 1 was 64 years, my lord. Petitioner number 2 was 60 years. Now petitioner number 1 is 73 and the petitioner number 2 is 69.
The challenge in the present petition is to an order dated 18th May 2013 passed by the learned SDJM Gunupur in ICC case number 15 of 2012 declaring the prayer made by the petitioners under section 205 CRPC for exemption from appearance in the trial court. Paragraph, the offences under section 498A, petition number 1 is now a septuagenarian, as is petition number 2. So stop. Petition number 3 is stated to be the brother-in-law of the complainant.
Complainant's daughter, man. Of the complainant's daughter.
Oh, the complainant's daughter. Sorry, complainant's daughter, and is staying in Bangalore.
Mine.
Even now.
Mine.
All right. Considering these facts, it is directed that the petitioners will appear. Has she been served here, sir? She is the opposite party.
Yes, my lord. Appearing for the opposite party, my lord.
All right. Why didn't you go for a compromise there, sir? The whole proceeding has been stayed for 8-9 years now. Okay. The 3 petitioners are permitted to appear before the concerned trial court. We'll fix a date which is convenient to you on 25th July. Monday, 25th July 2022. They're already on bail?
Yes, my lord.
They're already on bail?
Mine.
Okay. Whereafter their presence may be exempted till they're needed as and when they're needed for the trial. Full stop. The petition is disposed of in the above terms. Right. The interim order is vacated. The copy of the order be sent to the concerned trial court.
45. Item 45.
May I please, Your Lordship?
Yes.
This is a case where the present petitioner assailing the order of taking cognizance on the ground that no sanction order has been obtained.
Sir, all this you can urge, sir.
My lord. To that extent, my lord, I am humble submission before also. The 2 persons are the forest officials. They have initiated a proceeding against the complainant. While the complainant approached to release them from the custody, thereafter the present petitioner denied. For that reason, a case, my lord. Can it be, my lord? Then the government official will not scot free from the evil eyes of evil jaw of the
So we can urge all this. You've got to stay for 9 years, sir. No?
My lord, even though accepting for a moment, my lord, while the law has been laid down by this honorable court, so also by the honorable apex court, I have got that decision judgment, my lord.
Yes.
That is reported in 2022, volume 86 OCR, page 229.
Yes.
Pramod Kumar Swaya and others versus State of Odisha. This honorable court, relying upon the apex court judgment, was the entire proceeding, and as because no sanction has been obtained by the court below while taking cognizance. The language itself very much clear, my lord. No court shall proceed without prior sanction, my lord. That is the section 197, my lord.
Has the complainant been served, sir?
My lord?
Just see, complainant has been served or not?
My lord. Yes, yes. Complaint is the opposite part number 2.
No.
And notice has already been sent.
Has he been served?
That extent, my lord.
Served. What do you say? No sanction, he says they're both forest officers.
Lord, in fact, I don't have the instruction whether the sanction was there or not. But the 197 say if they are performing the act while they are discharging their official functions, my lord. Now, in this case, the petitioner has no one stated that he was while discharging official function. The
what is the complaint?
Complaint is not at page, my lord.
12.
Yes, 12, my lord.
12, my lord. You lords may kindly see you lords may kindly go to page 13, my lord. I am the complainant. I have filed this case against the forester.
They were found assaulting one Krishna Naik.
Yes.
Who happens to be my uncle in front of the beat house.
The forester abused me, and it's in Odia language, my lord, by taking the name of his caste. The forester
can urge all this at the appropriate stage. This is not official duty. Giving fist and kick blows and all that.
No, that is a complaint case, my lord. Because they have not approached before the police personnel. If that could have been, that matter could have been.
So these are all poor forest dwellers, sir. They can't go near any of these offices.
Because while both the petitioners were performing their duty in the beat house.
This is not duty, sir. This is the whole problem.
Because your lordship may kind see, entire document, my lord, it has been primarily found while they were performing their duty in the.
What is the duty, sir? What are you performing during your duty is questioning. That
because they are the forest guard, my lord.
No, doesn't mean because you're a guard you have to beat up people. That's the whole problem, sir. Yes. Permitting the petitioner to urge all the pleas raised, including the point regarding lack of sanction before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. The copy of the orders be sent to the concerned trial court. Yes.
Item 46.
None appears dismissed, non-prosecution. Interim order is vacated.
Item 47.
May I please your lordship? My lord, it is for crossing of cognizance, which is on page number 23. My lord, here the victim has already married the present petitioner, and
has she filed an affidavit?
My lord, the informant has filed an affidavit, which is in order sheet of the SDGM, which is in page number 24.
24.
Yes, my lord. My lord, in 164 statement also, which is written in Odia, the victim has written that she is residing in her in-laws house with the present petitioner, and they are together now, my lord.
Where do you get it? Page 24. Voluntarily eloped. All right. In the order dated in the proceedings of the learned SDJM, Bhadrak in GR case number 1586 of 2011, dated 14/12/2012, it has been recorded that under the victim girl, in a statement of section 164 CRPC, admitted to have voluntarily eloped with the accused, and that she is residing peacefully with him in her in-laws house. Paragraph. That the copy of the marriage certificate has also been placed as Annexure 5. Has she been served? Or she made a party here? Served. Despite service, none appears on behalf of opposite parties 2 and 3. In that view of the matter.
Lord, she has also deposed before the court. If her evidence has also been taken.
Even in her evidence before the court, the learned constable state informs that she has deposed to the same effect before the court concerned. That view of the matter, GR case number 1586 of 2011, pending the court of the SDGM Bhadrak, is hereby quashed. The petition is allowed in the above terms. No orders is to pass. The copy of this order be sent to the concerned trial court.
Obliged, my lord.
Special list item 48.
None appears dismissed, no prosecution. Copy of the order be sent to the concerned trial court.
Special list item 49.
May I please, Your Lordship?
Yes, please.
My lord, the very initiation of a proceeding under the provisions of Protection of Women from Domestic Violence Act is on a challenge. My lord, the main ground of challenge is that, my lord, the ingredients to constitute the
So
proceeding is not there.
That can be urged in the trial court, sir. All that can be urged in the trial court. Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. A copy of the order be sent to the concerned trial court forthwith.
Special list item 50.
None appears dismissed. The interim order is vacated. Copy of the order be sent. Yes.
51.
Same order.
Special list item 52.
My lord, item 52 on behalf of R.K. Raut. My lord, opposite party already died.
Died.
Yes, ma'am.
The court is informed that the opposite party has already died. That view of the matter, nothing survives in the present petition. It's disposed of. Interim order is vacated.
Yes, ma'am.
Right.
Special list item 53.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
I have filed this petition, my lord, to quash that proceeding, criminal proceeding by my lord Bolonga PS case number 98 of 2013. Only on the ground that no offences are made out. Your Lordship will be.
That can be urged, sir. That can be urged in the trial court at the appropriate stage.
Yes, Your Lordship.
Say, permitting the petitioner to urge all the pleas raised in the present petition before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. Copy of the order be sent to the concerned trial court.
Special list item 54.
None appears. This is not prosecution. Same thing. Interim order is vacated.
Special list item 55.
Item 55, my lord, petitioner has challenged the order of cognizance. I pray, my lord, liberty may be given to challenge all those grounds at the time of framing.
Same order. Permitting the petitioner to urge all the grounds raised before the trial court at the appropriate stage. The petition is disposed of. Interim order is vacated. Yes.
My appearance.
All right. His appearance may be noted.
Special list item 56.
None appears. This was non-prosecution. Interim order is vacated.
Special list item 57.
None appears. Dismissed, non-prosecution. Same order.
Special list item 58.
Same order.
58 may I mean virtual mulmarship.
58.
Case. May I mean virtual mulmarship.
All right.
58 my lordship. My lordship.
Yeah.
Case.
Yes.
My lordship, that order, my lordship, cognizance has been taken under section, my lordship, 342 and 323 and 294 of IPC, my lordship.
So you can urge all the pleas at the appropriate stage in the trial court. All right. Permitting the petitioner to urge all the pleas at the appropriate stage, the trial court, the petition is disposed of. The interim order is vacated. Copy of the order be sent to the concerned trial court.
Special list item 59.
May I please, Your Lordship?
Yes.
My lord, in this case, my lord, the petitioner is the husband and has filed the cognizance order. Cognizance taken under section 498A, 406, 506 IPC and section 4 of DPR. What has happened in this case, my lord? In fact, my lord, the divorce was allowed on 27/8/2011. Your lords will get at page 10, annexure 2. And after that divorce was allowed, 1.5 years after that divorce was allowed, the affair has been lost.
I know. So has she been served, sir? Just find out if opposite party number 2 has been served. Unless she files an affidavit, how do we quash, sir? See, obviously the alimony or whatever agreed was not paid. That must be the reason.
No, my lord, that is not.
Divorce has been allowed. Divorce has been allowed.
I know. PK Mohanty is appearing. PK Lanka. No, but how do we know there's not any subsequent development? We don't know that.
Right. Subsequent development, in fact, my lord, she has lost the affair on 21st December 2012, alleging the incident of the year 2003, my lord.
Oh,
3000 page 15, though it is Orissa. On 4/3/2003, she was
Correct.
tortured. That is the allegation.
all right. You say opposite party number 2 does not appear despite service of notice. The present petition has been filed seeking the quashing of order dated 15th April 2013 passed by the HDJM Kendrapada, taking cognizance of the offence under section 498A IPC in GR case number 1370 of 2012. That's the only offence, sir?
406, 506 years there.
498A, 406 and 506.
Read 4 of DP Act.
And
Read
section
4 of DP Act.
Yes.
Read 4 of Dowry Prohibition Act.
Dowry Prohibition Act. The fact of the matter is that the divorce has already been granted to the parties by the order dated 27th August
2011.
Yes, sir.
2011 of the Family Court, Cuttack, in civil proceeding number 1047 of 2009 under section 13, capital B, right?
No, my lord, under section 13.
Okay. Of the Hindu Marriage Act 1955. So that order has become final. The complaint itself seems to have been filed much later on
21st December 2012.
21st December 2012.
Page
Respect of events that took place in 2003. So clearly the complaint itself is time barred. Without appreciating these facts, the trial court appears to have proceeded to take cognizance of the offence by the impugned order. Paragraph with opposite party number 2 not appearing despite service. The court, the above arguments of the petitioner remain uncontroverted. Paragraph. Consequently, the order dated 15th April 2013 passed by the SDGM Kendrapada in GR case number 1370 of 2012 is hereby quashed. The petition is disposed of.
SLE item 60, please, Your Lordship. Your Lordship, this case, we are challenging the order of cognizance, my lord, but however, my lord, this is, if I may say so, my lord, is squarely covered by the latest judgment of the Supreme Court, my lord. I'm reading a judgment. My lord, once I'll take your lordship to the facts as well. But my lord, para 18, squarely covered. This is a case, my lord, where the in-laws, and before your lordship, it is the in-laws, not the husband, which is before your lordship. The Supreme Court, my lord, in this judgment clearly says that if the allegation or omnibus, general allegation against the in-laws, then they should not face the tribulations of the trials, my lord.
1 minute, has she been served? See, she means.
But in the meantime, divorce has already been granted, but that was post this FIR. Divorces has been, I've already got a copy, my lord, in 2016.
But all 7 have come here. This includes the husband as well.
No, husband is not there, my lord. The first is the
father-in-law.
Father-in-law who has passed away, my lord. Mother-in-law is alive. 3, 4, 5, and 6 are brother-in-laws. 7 is sister-in-law, my lord. Husband is not here, my lord.
All right.
My lord, may kindly have a glance to the judgment, my lord. Para 18, my lord. 5 line from the top, my lord. It is further manifest. Yes, from the said judgments that false implication by way of general omnibus allegations made in the course of matrimonial dispute, if left unchecked, would result in misuse of the process of law. Therefore, this court, by way of its judgments, has warned the courts from proceeding against the relatives and in-laws of the husband.
What are the allegations here? It's all Noria.
My lord, I have already got a copy of it. I have already got a copy of for your lordship, my lord, in English. Let me kindly have a glance. I'll give a copy to the state. My lord, may kindly see, and I quote, my lord, I, complainant Mimi Kamila, got married to Narendra Kamila, who is not a party here, 5th son of Bhagavat Kamila, as per Hindu ritual. During my wedding, I have given jewelry, furniture, fridge, television, gold ornaments for the groom Timex watch, rupees 60,000 for a Honda bike, along with rupees 1 lakh as dowry. The details of all my dowry items have been listed later in this report. My husband deceived me into marrying him by falsely portraying as a successful businessman. After 8 days of my wedding, my father-in-law, mother-in-law, this started abusing me in filthy language, and my husband, asked me to get 1 lakh from my house for business. When I asked for my brother for the money, he said he cannot arrange. The aforesaid people kept on torturing me. My husband beats me during night after getting drunk. Now, my lord, my next page, my in-laws along with my husband kept torturing me. Did not give me food to eat and abused me physically and mentally. My husband's elder brother's wife, my lord, elder brother got married to Latika Rana in 2009, and after that, Latika Rana also abused me physically and mentally. Now, my lord, may kindly have a glance to the judgment.
What is the date of this complaint?
My lord, this date is, my lord, this FIR is 14/12/2022, page 8.
Date of marriage is?
My lord, date of marriage is
2008.
12/5/2008.
Yes. No dates given. So if it is 8 days after marriage, then this complaint is made after 4 years.
Exactly, 4 years after delay. And these are exactly the allegations, my lord, which Supreme Court go into very detail. After this, it's a February 2022 order, my lord, wherein they have also discussed, my lord, the Latika Kumari case, and wherein at the end, my lord, it says, the Honorable Supreme Court says in para 19, coming to the facts of this case, that particular case, upon a perusal of the content of the FIR, it is revealed that general allegation are leveled against the appellants. The complainant alleged that all accused harassed her mentally and threatened her of terminating her pregnancy. Furthermore, no specific and distinct allegations have been made against either of the appellants. Herein, none of the appellants have been attributed any specific role in furtherance of the general allegation made against them. This simply leads to a situation wherein one fails to ascertain the role played by each accused in furtherance of the offense. The allegations are therefore general and omnibus and can at best be said to have been made out of account of small skirmishes. Insofar as husband is concerned, since he has not appealed against the order of the High Court, we have not examined the veracity of the allegation made against him. However, as far as appellants are concerned, the allegations made against them, being general and omnibus, do not warrant prosecution. And they have quashed the FIR, my lord. Also, my lord, just to bring it to your lordship notice, my lord, they have already been, divorce has already been granted, and pursuant to that, permanent alimony have already,
all right.
Again, permanent alimony has also been paid, my lord.
All right.
I'll also do.
All right. The present petition is by the two in-laws and the brothers-in-law and sisters-in-law of the complainant. Questioning an order dated 27 September 2013 passed by the learned SDJ Sadar Balashore in CT numbers 2812 of 2012, corresponding to Balashore Town PS case number 450 of 2012, dated 14/12/2012, against the petitioners for the offences under section 498 capital A IPC, comma
506
406 red with 34 IPC and section 4 of the Dowry Prohibition Act 1961 paragraph. At the outset, counsel for the petitioner points out that petition number 1 has expired during the pendency of the present petition. Full stop. The husband is not one of the petitioners in the present petition. Full stop. We are concerned, therefore, with the mother-in-law, the sisters-in-law, and brothers-in-law of the complainant. Paragraph. The counsel for the petitioner further points out that the marriage between the son of petition number 1 and the complainant has been dissolved by a decree of divorce dated 17 March 2016, granted by the Family Court Baleshwar in CP number 307 of 2012. Apart from placing the copy of the said judgment on record, counsel for petition has also placed the order sheets which show that on 30th April 2016, the permanent alimony as directed by the family court has already been paid to the complainant. Paragraph. A translated copy of the FIR of the complaint on the basis of which the FIR was registered has also been placed before the court. Full stop. Counsel for the petitioner relies on the judgment of the Supreme Court in Kayakashan Kaushar, alias Sonam versus State of Bihar, 2022 SCSC online SC 162, where the Supreme Court observed that vague allegations in FIR registered for the offences under Section 498A and 506 read with 34 IPC cannot be vague and unspecific. Full stop. The Supreme Court observed as under, take from whole of para 18, A to A, and then
19.
Yeah, 19, 18 and 19, A to A. Paragraph. In the present case too, on a perusal of the translated copy of the complaint, it is seen that although the marriage took place on 12th May 2008, and the complaint pertained to events that happened 8 days after marriage, the complaint itself was filed only on 14/12/2012. Further, there is a broad sweeping allegation against all of the present petitioners about abusing the complainant 8 days after the marriage, open quotation, in filthy language, unquote, whereas the specific allegation of demand of dowry is made only against the husband. Paragraph. The other allegations about denial of food and abuse both mental and physical against the present petitioners are totally vague and unspecific. Full stop. It is almost similar to the allegations in Kayakashan Kausar, alias Sonam Supra, as set out in para 19 of the judgment, which has been extracted here and before. Paragraph. Consequently, this court, in the above circumstances, has no hesitation in quashing the order dated 27th September 2013, passed by the SDJM Sadar Baleshwar, taking cognizance of the aforementioned offences in CT number 2812 of 2012, and all other proceedings and orders consequent that. The petition is allowed in the above terms, no orders of cause. Right in the beginning, we said despite service of notice, and someone and lawyer entering appearance on behalf of opposite party number 2, today none appears on her behalf.
Grateful, man.
My lord, my sister-in-law of senior counsel, Santanu Kumar, suddenly is dead. For which one adjournment kindly prayed.
Which matter is this?
Sir, 61.
Next matter. 61.
Next one. All right. Counsel for the petitioner is stated to be in some personal difficulty. A list on the 24th June.
Specialist item 62.
None appears. Dismissed, non-prosecution. Interim orders vacated.
Specialist item 63.
Please, your lordship. My lord, counsel for the informant is absent. That's why may I pray some time.
Why should it be, sir? They're absent. They've been served, no?
Yes. Well, yes. Sorry.
Despite service, she's absent.
No, my lord. This is the first time since after long periods of a gap, matter has listed before your lordship.
Who are you for, sir?
I am for the petitioner, my
lord. So what's your problem?
Because counsel for the informant is absent.
It's all right. You first tell us what the case is about.
Been settled, my lord. Matter already been settled. Matter already been
what is there to show? Compromise report.
Yes, my lord. I have submitted.
This is only a handwritten page, sir.
I mean,
you can place it before the trial court. Get the statements recorded in the trial court.
My lord, I mean permitted to submit a translated copy of the compromise report.
This is a handwritten thing, sir.
Yeah, even I may be permitted to file affidavit on behalf of the informant.
You can do it in the trial court. Get the statements recorded. You say, counsel for the petitioner states that the compromise has been reached between the petitioners on the one hand and opposite party number 2 complainant on the other. He refers to annexure 2, which seems to be a handwritten document, not signed in the form of an, and signed in Orissa, which is not in the form of an affidavit at all, permitting the petitioners and the opposite parties to record their respective statements regarding such compromise in the trial court in accordance with law. The petition is disposed of. The interim order is vacated. The copy of this order be sent to the concerned trial court.
But my pray, my lord, petitioner was not on bail, my lord. Since registration of the FIR, petitioner challenged the proceeding, my lord. I may be permitted to surrender and release on bail.
That is all not part of this, sir. All right.
Specialist item 64.
Yes.
64.
None appears, dismissed, non-prosecution. The interim order is vacated. Copy of the order be sent to the concerned trial court forthwith.
Item 65.
May I please, your lordship? Here, my lord. Here, my lord, the petitioner challenging the criminal proceeding on the ground that, my lord, the petitioner is a government employee, my lord. On the date of occurrence, he was not present at the spot, my lord. Your lordship may kindly.
That's an alibi, please, sir.
My lord, kindly have glance, my lord. I have.
You can urge all that.
I have annexed the documents, my lord. Your lordship may kindly peruse. By the annexure 3, my lord. Movement order of the platoon commander.
What is the offense?
Offense, my lord, 354 arising out of the complaint case, my lord.
376, sir. Please. You can urge all this as appropriate.
354, my lord. Your lordship kindly peruse. 294, 354, 506, 34, read with section 3.
It's all right, sir. You can urge it all at the appropriate stage in the trial court. Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated.
Please, no.
A copy of the order be sent to the concerned trial court forthwith.
Appearing on behalf of the opposite party.
All right. Just put his appearance. All right.
Obligation.
Specialist item 66.
None appears, dismissed, non-prosecution. Interim order vacated. Copy of the order be sent to the concerned trial court.
Specialist item 67.
67 may I appeal, Lordship. I mean virtual membership. But in this case, my lord, the present petitioner challenging the question and set aside the entire criminal proceeding, my lordship, against the present petitioner. My lordship, in the instance case, my compromise affidavit has been already filed, my lordship. The petitioner number 4 and opposite party number 2, out of their love and affection, got married, my lordship, and leading a happy conjugal lives, my lordship.
All right. You say the affidavit of opposite party number 2, stating that she is now married to the petitioner and is leading a happy married life, has been placed on record. Despite service, none appears on her behalf. In that view of the matter, FIR arising out of PS case number 71 of 2013 in Khurda Sadar PS and the GR case number 793 of 2013 arising therefrom are hereby quashed. And pending the file of SDGM Khurda are hereby quashed. The petition is disposed of.
Specialist item 68.
Item 68, I pray for question of cognizance. It is a violation of statutory violation under section 15. Under section 15, that is,
Section 15?
Under section 50 of Environment Protection Act.
Environment Protection Act, okay.
Let them face the trial minor. Only small prayer is, they have filed an application under 205. Order is there, man.
All right.
They have rejected the petitioner.
All right.
Was
The
76
petitioner,
at that time. Now,
while as far as the prayer for quashing is concerned, it is open to the petitioner to urge all the pleas at the appropriate stage in the trial court in accordance with law. As regards the refusal by the trial court by the order dated 2nd January 2014 for exemption from of trial court, that is JMFC Audi in GR case number 333 of 2011, refusing the plea of the petitioner under section 205 CRPC is concerned. The petitioner will appear before the petitioners will appear before the concerned trial court on 25th July.
Small prayer, kindly look at petitioner 1. His age was 76, now he is 84. Ankle operation, he may not move, my lord. Only his application may be allowed.
All right. Well, petition number 2 will appear. Petition number 1, who stated to be now
84.
Sir, it is 52. He was 52 years in 2014. Just come to page. I don't know what page number this is. Anyway. Is Shivdas Mahapatra, right?
Wait, please, your lordship.
Charanjit Singh Griwal, my lord. Petitioner number 1 is Charanjit Singh Griwal.
Item number 293, 68 serial number.
68.
The
Oh, I
Sivdas Mahapatra, my lord, item number 69.
Oh, I see, 68, all right. Considering that the petitioner, then you have to redo all this. Huh? The challenge to the present petition is to quash criminal proceedings being 2CCC number 24 of 2013, pending the court of the SDJ in Bonai. The second prayer is for quashing an order dated 19/2/2013, passed by the said court, taking cognizance of the offence under section 15 of the Environment Protection Act against the petitioners. So, as far as these prayers are concerned, we will open to the petitioners to urge all the pleas raised in the present petition at the appropriate stage of the trial court. Where is the order refusing appearance?
That is 11/6/2013, that page 16, my lord.
You have not challenged that, sir. That has not been challenged here.
Liberty may be given.
No, no. It will be open to the petitioner to renew the prayer under section 205 CRPC at the appropriate stage of the trial court.
And petition number 1 case may kindly be considered sympathetically. He is
Sir, there is not even a prayer for that here, sir. No prayer. You say the petition is disposed of, interim order is vacated, copy of the order be sent to the concerned trial court forthwith. Now 69. Yes.
On behalf of
69.
Mr. Bhabashis Das, the conducting counsel is out of state as his sister has died, my lord. The
Hey,
matter
you
may
can
be-
argue what is there in this? Nothing in this. You can easily argue, sir.
The present application has been filed in connection with PS case number 72 of 2011 in GR case 333 of 2011, my lord, for quashing. The offences are under section 498A, 323, 294 of IPC, my lord.
Both of them are what? Their father-in-law and mother-in-law?
No, my lord. The sister and the husband of the sister, brother-in-law and sister.
Huh.
They are not
Sister
connected.
and brother-in-law.
Yes, my lord. They stay at Cuttack and they are no way connected to the case. Just because.
What are the allegations against them?
The allegations are, my lord, for mental torture, physical torture, and abuse her in filthy language and assaulted her. Only thing is that they had the informant and her husband.
The
had
opposite
some
party number
family
2 be
dispute.
served? No. Sir, unserved notices have also not been received back
Yes, my lord.
from opposite party number 2 for 8 years now.
Prayer for discharge has been turned down.
Sorry?
Prayer for discharge has been turned down. Page 9, you also
Mm.
Page 9, bottom portion.
You say neither AD card nor unserved notice has been received back from opposite party number 2. In other words, for last 8 years, opposite party number 2 has not yet been served. The court does not propose to grant any further indulgence in this regard to the petitioner, permitting the petitioners to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. Copy of this order be sent to the concerned court forthwith. All right.
Specialist item 70.
None appears. This was not prosecution. Interim order vacated.
71.
71, may I please? My lordship, the petitioner is challenging for quashing and set aside the entire criminal proceeding match. The FIR has been registered under section 363 and 34 of IPC, my lordship, which is in Annex 1, my lordship. The section, the statement of the victim has been recorded and my lordship, which is in Annex 3 and Annex 2, my lordship.
Page 12. Page 12, paragraph 7, your lordship. Your lordship, can see paragraph 7 of the petition. It was stated. And her statement is at Annex 2, page 12.
What is the statement?
Page 12, on Annex 2.
No, tell us, it's in Orissa. Page 12 is in Orissa, sir.
On my own will was I married to my husband.
Oh, so she's married?
Yes, married.
The statement of the victim under section 164 CRPC admitting to having married the petitioner and living with him peacefully is on record.
And I'm residing in Karnataka.
They are now residing at?
In Karnataka, happily, as per the statement, in Karnataka.
In Karnataka. They are now residing in Karnataka. That be the matter, CT case number 587 of 2012, arising out of Jaleshwar PS number 185 2012, pending the code of the JMFC Jaleshwar, is hereby quashed. The petition is disposed of. A copy of this order be sent to the concerned trial court.
Specialist item 72.
Please, your lordship. Lordship, here the Offences alleged under section 498, 323, 506, 506, 406, 34 IPC and read with section 4.
You are the husband.
Yes, the petitioner number 1 is the father-in-law, 85 years, and 2 is the husband, and 3 is the sister-in-law of the informant opposite part number 2. In the meanwhile, the marriage between the opposite part number 2 and the petitioner number 2 has been annulled by the by a decree of divorce. And your lordship may kindly find at page 4 of the order of decree of divorce, paragraph 4 at page 4. Let's be in order to prove the contention of the petitioner has examined 2 witnesses and exhibited 3 documents. While on the other hand, the OP neither examined any witness nor exhibited any documents. PW1, which petitioner has corroborated his petition and has in his cross-examination stated that no dowry was received during marriage. PW2 has in his evidence corroborated PW1. This being the state of affairs, where all the witnesses corroborated the petitioner's story and the OP neither challenged the petitioner's version nor has given any evidence to prove her version. It can be clearly stated that
served opposite party number 2.
That's it.
Appearance, all right. None appears on behalf of opposite party number 2 complainant, despite Wakalatnama having been filed on behalf earlier. Paragraph. The present petition is by the father-in-law who is now aged 85 years, the husband and the sister-in-law of the complainant. They seek the quashing of GR case number 650 of 2011 arising out of Kujang PS case number 270 of 2011 pending the court of the JMFC bracket P Kujang. Paragraph. Counsel to petitioner at the outset points out that by an order dated 12/12/2017 of the Civil Judge Senior Division Kujang in CP number E-60-2016 bracket 32-2014 bracket, the marriage between the petition number 2 husband and opposite party number 2 complainant wife has been dissolved by a decree of divorce. That order has become final. Good stop. Even before the said civil court, no evidence was laid on behalf of the opposite party number 2 complainant. Whereas the husband's version that she had mistreated him and left his company for more than 2 years remained uncontroverted. Paragraph. Since the above facts have not been controverted by opposite party number 2, this court quashes GR case number 650 of 2011 arising out of Kujang case piece 270 of 2011 pending the court of the JMFC bracket P Kujang. The petition is disposed of. A copy of this order be sent to the concerned trial court forthwith. I move it.
Specialist item 73.
None appears dismissed in non-prosecution. The interim order is vacated. Copy of the order be sent to the concerned trial court forthwith.
Specialist item 74.
I may please your sorry, I am in virtual mode, my lord. My
Yes.
lord, the allegation against the petitioner is under section 363 IPC. Allegation is that the petitioner kidnapped the opposite party number 3, but the fact remains that they are fell in love with each other and they are married. I have annexed with the marriage documents, my lord, and they are now friends with the son.
Correct. Copy of the marriage document.
The notarial marriage was before notarial.
Notarial marriage.
Notarial marriage, they are now living peacefully, my lord, leading conjugal life and blessed with the children, my lord.
Okay. Despite opposite party number 2 having been represented by lawyers, today none appears on her behalf. It is stated that the petitioner and opposite party number 2 have been married.
Opposite party number 3, my lord.
3.
Opposite party number 2 is the informant.
All right. Opposite party number 3 have been married and are living peacefully. Copy of a notarial marriage certificate has been enclosed as Annex 2. With none of the above arguments being controverted by opposite party number 3. The court quashes GR case number 1235 2013 pending the court of SDJM Jagat Singapore arising out of and the FIR number 112/17 of 2013 dated 24/12/2013 under section 363 IPC and all further proceedings consequent that. The petition is disposed of, no orders to pass. Copy the order be sent to the concerned trial court forthwith.
Specialist item 75.
Item 75, my lords, no instructions.
No instructions, both petitions are disposed of, interim order is vacated.
I am obliged.
Specialist item 76.
May I please? It's a challenges the proceeding on the ground of passing the proceeding on the ground of compromise. Here the alleged offences are under section 147, 148, 323, 294, 354, 506. But the
147, 148 IPC.
My lord, 147, 148.
That's not compoundable.
All the offences are compoundable, but 3 SC/ST Act is there. In the meanwhile, the matter has been compromised. Your lordship kindly have a glance to annexure 4, page 18. Even the complainant also filed, informed also filed.
So this compromise itself is wrongly spelled. Why don't you get your statements recorded in the trial court? That's better, sir.
With that observation, lordship dispute.
All right. It is claimed that the compromise petition has been signed by all the parties, permitting the petitioners and the opposite parties to opposite parties
my lord.
To have the respective statements recorded in the trial court pursuant to the said compromise. The petition is disposed of. The interim order is vacated. A copy of the order be sent to the concerned trial court forthwith.
Obliged.
Specialist item 77.
77, my lord, challenging the order of cognizance on the ground of
leaving all pleas open to be urged before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. Copy of the order be sent to the concerned trial court forthwith.
Specialist item 78.
None appears. Dismissed for non-prosecution. Interim order is vacated.
Specialist item 79.
79, my lord, permitted to withdraw. I'll place all this at the time of charge. Only your
Counsel for petitioner seeks leave to withdraw this petition with liberty to urge all the pleas raised here at the appropriate stage before the trial court. The interim order is vacated. The petition is disposed of as withdrawn with liberty is paid. Copy of the order be sent to the concerned trial court forthwith.
Specialist item 80.
None appears. Dismissal non-prosecution. Interim order vacated.
Item 81.
Sir, on behalf of Mr. Bigyan Kumar Sharma, no instruction.
No instructions. Disposed of. Interim order vacated.
Specialist item 82.
None appears. Dismissal non-prosecution. Interim order vacated.
83.
None appears. Dismissal non-prosecution. Interim order vacated.
Item number 84.
Item number 84, 85, 86, no instruction.
No instructions. Disposed of. Interim order vacated. All right. His appearance at 85.
Interim order.
Vacated.
Specialist item 87.
None appears. Dismissal non-prosecution. Interim order vacated.
87, I am appearing for OP. There is no one.
87 specialist. CRLMC 2843 of 2014.
Yes, sir. So I am for opposite party.
This for opposite party. All right.
Specialist item 88.
88, my lord, is challenging the proceeding and the cheat fund case. This petitioner is no way connected. He is the salaried employee. No director, no manager, and the owner has not been made an accused.
What is the affair? What are the offences?
Offense for 20 and 120p IPC.
This is the chit fund, sir.
Chit fund.
You can urge all these
I
places.
am the salaried employee. I
All
am
right, sir.
connected.
You can challenge all this.
Director, manager, owner has not been accused.
That's okay, sir. This is IPC offense, not those 128 and all that. Only those where you have to make company a party. IPC offenses is no such compulsion. All right. You say permitting the petitioner to urge all these pleas before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. Copy the order be sent to the concerned trial court.
One passer. Specialist passed over matter item 36.
May I please, my lord?
Yes, please.
In this case, the petitioner seeks to challenge the criminal proceeding on the ground that the allegations are inherently improbable, absurd, and the case has been foisted only with the malicious intention to wreak vengeance on the petitioner.
What about opposite party number 2? Served or not?
Yes, ma'am. It has entered appearance on.
I am for the opposite party number 2, my lord.
You are for opposite party number 2?
Opposite party number 2.
But the petitioner, he serves for a finance company, my lord. Admittedly, my lord, the finance company had advanced loan to the opposite party. He defaulted in payment of the EMIs. And thereafter, my lord, the vehicle was repossessed. And after vehicle was repossessed, after 2 months thereafter, a complaint case was filed, pursuant to which the investigation was taken up under 156(3). A direction was issued for registration of the FIR. Investigation was taken up, and thereafter the police submitted a final form saying that the case is false. It's a mistake of fact.
Protest petition.
My lord?
Protest petition is filed.
No protest petition is filed. But thereafter, my lord, the report is submitted to the learned magistrate. The learned magistrate, in the absence of any protest petition also, he takes cognizance of the offences. He can
do that.
Yes, ma'am. Takes cognizance of the offences and issues process against me. But thereafter, we file the order before the learned sessions judge. The learned sessions judge upholds the order of the
Special
learned
court.
trial court magistrate. Thereafter, this application under section 482 has been filed. But I am squarely covered by the judgments of the Honorable Apex Court right from 1979 onwards, till 2013, wherein the Honorable Apex Court, along with all the High Courts, have consistently held that suppose if the agreement permits the financier to take possession of the vehicle, and thereafter a criminal offence is alleged, then on the facts of the case, the case is not made out. May I read those judgments, the relevant motions?
People basically went and picked up whatever. What is a truck? Is it?
It's a bolero, my lord.
Bolero. So you must have just picked it up from the middle of the road somewhere.
Yes, my lord. That's normal. And we intimated, your lordship would see under Annexure 2, we have intimated the police prior to reposition, post reposition.
Well, where is the SC/ST Act and all come?
My lord, SC, my lord, since my lord would see when the entire allegations, my lord, is found to be improbable, my lord, and it has been foisted only out of vindictiveness. So, my lord, he being and obviously he belongs to SC. He is naturally given that section, my lord. Now,
are you opposing this, sir?
My lord, I have filed a judgment.
You did not even file a protest petition. How can you oppose? You never filed a protest petition.
Protest petition is a file.
When?
After the protest petition filed, the cognizance has.
He said no protest petition is filed.
The order is there, the record is silent about that.
Where is that, sir? Show us. Where is your protest petition?
After the protest petition, the cognizance has taken.
Actually, he's saying the other way around. He says, despite no protest petition, cognizance was taken.
Annexure 6, page 35 is the order of the learned magistrate. Lord, you would see at page 37. The order dated 12/3/2012. It starts from page 36, my lord.
Yes.
The case record is put up today on the strength of the advance petition filed by the learned counsel for the accused persons, wherein the learned counsel submitted that despite the admission of the final form by the IO, the same has not been reflected, and in necessary orders heard on the petition, peruse the entire case record. On perusal of the same, it is noticed that in view of the final form dated so and so, the IO has submitted the final report on the ground that a mistake of fact. The same had not been placed before the presiding officer since then. Call for an explanation from the CSA in the matter. As far as available materials, that is the case diary, 161 statement, and the witnesses, the complainant petition registered as FIR and other relevant documents as concerned, and to hold a prima facie case is made out under section so and so, so and so.
So no protest petition, sir.
My lord,
no protest
petition has filed.
There's no mention of that by the trial court.
In fact, a ground was urged before the learned sessions judge that in the absence of a protest petition.
How does he deal with that?
He has said that it's not required.
38, page 38.
Yes. Annex 7 at page 30. Paragraph 3, my lord, the learned court below even not so much as issued a notice to the complainant to object to the result of the investigation. And it's squarely covered by the judgments of the Honorable Apex Court, my lord. If I may be permitted to read out the relevant portion, my lord, we authorize that how this case has been registered against the family.
The petition has been filed. There is a complaint petition.
No, obviously the complainant belongs to the SC.
Yes, my lord. My learned is talking about it's arising out of a 156 P application. A complaint case was filed. Yes. Subsequently, FIR was registered. The investigation was taken up.
The complaint has been filed on 15th September 2008. Charge sheet has been filed on 17/10/2008.
Annex 20 is the complete case. Sorry, Annex 4, my lord.
Page 20.
Why can't you urge these places, sir? You can urge these pleas before the trial court.
Both should
And
have
seek
been
discharge on that basis.
Yes, both should
I
have
think
been
that's a
clocked.
better thing. You say permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage.
Both should have been clocked
Before the
under
trial
section
court,
210 service.
the petition is disposed of. The interim order is vacated.
Your
A copy of
Lordship
the
may
order be sent to the concerned trial court.
My lord, the present petitioner is on bail, my lord. Your lordship may kindly indicate, and summon was issued to him. Let fresh summon be issued to him.
Why should we say anything on that? This is only a quash petition. Let's not say anything on it. All right. Over.
Once the
Item number 1.
Actually, the matter has become infructuous in as much as the petitioner has already resigned from the bank.
Okay.
He has his resignation has been accepted, and he has taken all service benefits.
All right.
As per the staff service rules.
All right. Just shows that.
I am appearing for the opposite party, my lords. On my instruction, my lord, there is 1.34 lakhs has not been paid to him.
I don't know, my lords. This is
That you make a representation. That's a very small thing, sir.
Because of pending of the review application, they have not paid to him.
No, if at all anything is due, my lords, we have to make.
Mr. Milan Kanungo, learned senior counsel, informs the court that opposite party has already resigned from the appellant bank and her resignation is suddenly accepted. Counsel appearing for the opposite party states that some amount is still due to her as part of her retirement benefits. It will be open to her to approach the bank for that purpose. The review petition is disposed of.
Deeply.
The matter.
1.
Please, Your Lordship. Lords, in the meanwhile, another order has been passed by the High Power Committee. I am giving a copy.
Okay.
I have sent a copy to Justice Alvarez.
So they extended it further. Then let's keep it after vacation. They extended by how much?
My difficulty, my lords, is that as per these orders, these parole furloughs will not be counted for the period.
All right. Anyway, so what does it matter, sir? You're not harmed in any way.
First extension was 50 days, 15 days.
Now?
Second extension, 30 days. Now another 15 days.
So when does it end?
Furlough period is
I was due to
5 weeks.
surrender on 16th, my lords. So now 15, 30 and 15 in 60 days more.
So we keep it in June itself? 24th June, suppose subject to your convenience.
25th.
No, 24th is Friday, sir. So let it be then 8th July will be too much.
No, can it be the next week Tuesday then?
So we'll have to sit, only that we have to sit as a special bench. That's all. That's the only inconvenience.
Furlough is a conditional release by the authorities.
Correct. No, but when is it ending is the question. 60 days from now.
60 days from 16th, my lords, because my furlough will end on the 16th.
16th.
Now, by virtue of these orders, they stand extended automatically.
So 16th June onwards, 60 days.
Yes,
then it can come.
No,
in July.
16th May onwards.
Anyway, so 8th July. 8th July, sir.
Apex Court's order is that until and unless there is an order passed in the suo motu petition, they should not be directed
All
to
right.
come
You
into
say Mr. Devshish Panda, Learned Counsel for the applicant, has handed over minutes of the High Court Committee of 5th May 2022, by virtue of which the applicant's furlough gets extended.
Furlough, but subsequently it is parole, because furlough is only for 5 weeks
All
in
right.
a year.
Parole, okay. Parole, sir?
My lords, as per the order which I have annexed, your lordship may see, annexure 1 series in the bail application, furlough leave, my lords. It is all stated furlough leave.
Let's keep it at
Furlough
that.
can be at least
Page
35 days in a
page
year.
But
7,
these are COVID matters, sir.
Yes,
So that's a different thing.
that is fair.
page 9 also, it is special furlough leave.
Okay, this applicant's special furlough leave stands extended by 60 days from 16th May 2022 onwards. In that way, the matter lists on 8th July. All right.
Yes, may permitted to file affidavits of the DIG.
Yes. You see, file it in the registry. No.
Subitem number 3 matters.
Yes.
There matter call for the antecedent connection of the jail master.
Subitem 3.
I am standing at the same footing matters. I am getting the bail for the first time. And jail.
No, he was to take instructions.
I have not got instructions so far that accused.
All right. We'll keep take it up on 8th. List on 8th only. All of it. All right.
For admission item number 1.
So Salve is there?
Yes, ma'am.
Yes.
My lord, we have filed an affidavit. I wonder if it is readily available to your lord.
My lord, it's not scanned on your lordship's physical.
All right. All right.
On
You filed it
19th
yesterday.
of May.
Yes.
If your lordship permits me to read from paragraph 5.
Right.
Page 2, my lord.
Yes.
Page 2. The deponent submits that as per the IPM notification, ASP for iron ore grow for 55% for the month of April 2021 is 2687 and 1532. However, iron ore grade below 51, petitioner has been able to realize 600 metric tons and 500 fines for sale price. They are compelled to make royalty payment at the higher rate. So this is what we said makes it this. The sales were all to related parties, so most probably IBM may want to discard them. So I have not suggested something in para 6.
Yes.
The way forward. We undertake that within 30 days of the ASP iron ore grade below 51% being notified by IBM, I will deposit the premium, royalty, NMET, and DMF in advance to meet its obligation under the agreement for the first mining year, right from July 20 to 21, and then from 3rd July to 2nd July 22. So, for the present, I will continue mining. I will keep the ore in place. I will not do anything.
Okay.
The moment they notify the price within 30 days up to July 22, I will make them.
Parija?
Lord, your lordship may only say that IBM should notify it within a prescribed time. Otherwise, this remains very open.
I joined my friend, my lord. Let him.
I am submitting.
IBM within. In 10 days, they should notify.
Mr. Pari, what is your instruction?
Well, so I obtained the instruction, my lord. The department is ready and willing to publish the tentatively within 27 to 29 June 2022. It is May, and after getting the all average prices, it will notify it within 27 to 29th June 2022, my lord. This is the cut-off date based on which the IBM will clear all. Because after getting all the sources uploaded from different sources, taking average of the same, they will notify it.
So, between 27th and 29th June, they will notify.
Yes, yes.
So, Mr. Salve will just record whatever you said in para 6.
Yes, my lord. Your lordship may say no later than 30th June will IBM notify.
Correct, correct.
And within 30 days of that, I shall make the payment.
All right. You say, Mr. Pari, Leonard, Assistant Solicitor General, Government of India, states that IBM will notify the ASP for iron ore grade below 51% between 27th and 29th June 2022, and in any event not later than 30th June 2022. The said statement is placed on record. Paragraph.
Only lordship may interpret this for the month of April 2022. For the month of April.
Once we have a price, we'll make the payment.
All right. For the month, okay. For the month of April 2022. All right.
22.
Mr. Salve, Leonard Senior Counsel appearing for the petitioner, applicant, refers to the additional affidavit filed today, where in para 6 it is stated as under. Reproduce the whole of para 6. Paragraph. Mr. Parija states that the above arrangement is acceptable to the government without prejudice to its rights and contentions.
The lordship may say purely as an interim arrangement.
Yes, purely as an interim arrangement. Full stop. The statement made in para 6 is also placed on record. The petitioner will make payment as undertaken, subject of course to IBM notifying the prices ASP for April 2022, not later than 30th June 2022. So we dispose of the application, Mr. Sagar.
Yes, sir.
Lord, the IA will be disposed of. The
IA.
matter, your lordship may call the mail matter in July. By that time, actually, we will know what is happening.
All right. This application is disposed of. The main matter will have it in. It's not part heard before us or anything. So it is before the regular bench.
Yes, yes.
Yeah, the main matter we said place in the roster bench. 20th July, is that all right, Mr. Salve?
Yes.
20th July. All right.
Lordship.
All right.